We're going to get started. Welcome, everyone. Allison Schaberg here, Consolidated Planning Group. Thanks for joining us today for our webinar. A couple housekeeping items. We are going from 12 to 1 today, so if you're planning your day, we will be done by 1 o'clock. You are in webinar mode, so we can't see you or hear you, so sigh of relief there. But we do know you're there, and we are glad that you're here. And today, what we are doing is we are partnering with Heidi Angel, an attorney, and she's going to be talking to us about wills, trust, and guardianship. And so what I will tell you is, we're going to be scratching the surface on these things, and we're going to get through as much as we possibly can. These are topics, wills, trust, and guardianship are topics that we could have an entire webinar on one of those topics. So we're going to kind of hit the highlights on those things. We invite you to put your questions in the chat box. We're going to get to as many questions as we can. I'm going to monitor the chat box and I'll read those out to Heidi. Today's webinar is being recorded, and you will get a copy of the recording and a copy of today's slides later on today by email. So Consolidated Planning Group, we are a holistic special needs financial planning firm, and there's oftentimes a lot of confusion on what my role is and what I do and what someone like Heidi does. A lot of times Heidi will get calls on the financial side and we get calls on the legal side. And I always try to kind of shorten that up and just say, they're the legal documents, they're the paper, and we're the money. It's kind of when it comes down to it. So when we're planning for special needs, there's a lot of careful consideration that goes in to planning, and some of that and what we're talking about today are those legal documents that are so very important. But when it comes to planning for a loved one with special needs that may have care needs beyond our life, it comes down into careful planning financially and how much, is needed to fund a special needs trust. How do we have money in the right buckets? What do we need to know about SSI and Medicaid, SSDI and Medicare and those types of things? So that's kind of where our firm comes in to play. We put lifetime protection plans in place, and we're able to help people figure out how much money actually needs to go to fund that trust and that future care. So we're glad you're here today. Like I said, don't be shy. Put your questions in the chat box as we're moving along. If you've got the question, somebody else probably does too, so you'll be helping somebody else as well. Heidi, it is so great to see your face again, and we're glad to be partnering with you again. So talk to us about you and your firm and what we're going to talk about today.
Okay, thanks, Allison. I appreciate that introduction. I also appreciate everybody being here. And I appreciate Allison's great overview of helping to understand, the several advisors that may be involved in your planning. And so there's pieces that I handle from a legal perspective. There's pieces that Allison's group handles from her financial perspective and Social Security Administration perspective. And so all of those pieces are really important. So kudos to all of you for just trying to figure all of this out. It's important, and a lot of these webinars are available and really helpful, I think. So thank you, Allison. So I'm an estate planning attorney. I do estate planning and probate. I used to be a teacher. I have a family here. Sparky's the furry member there, our dog. And so my practice focuses on estate planning, probate, and then part of my estate planning is special needs planning and also guardianship work. And so that's, what I'd like to speak about today. And really primarily here, and I mentioned on that Get to Know Me that I served on the Down Syndrome Partnership of North Texas board. That's an organization that's been important to me and my family. And so as a part of my practice, I do handle guardianship, I handle special needs trusts and planning. And so my goals really for today are to help give you an overview and context of the legal structures that are in place and that are relevant to your loved ones with disabilities. It can be, I know, overwhelming, and it can be frustrating, and just thinking about calling an attorney to handle these things can seem daunting. And so, what I hope to do is just give you a good, clear structure to think through this so that ideally you're a better consumer of legal services. So that's the piece that I'm doing. I also just want to give you these legal structures because these are the laws that are in place today. Laws change. And we all, as people who care about individuals with disabilities, are the ones who want to work with advocates and with self-advocates to make changes that benefit the lives of people with disabilities. So it's important to understand the legal frameworks that we're starting from. So
Heidi, you mentioned about laws changing, and I hear this too, and I know that, we attend that UT special needs, planning conference and things like that, which is where they start discussing all these law changes and stuff like that. Having said that, could you provide a recommendation of how often, for instance, if you have a special needs trust or documents like that in place, how often should you have that reviewed in light of laws changing?
Yeah, that's a really good question. So my general recommendation for my estate planning clients, just generally, is you need to review these documents every 5 years. Now that changes, if someone that you've named as a trustee or an executor or someone particular has passed or something's changed with the individuals you've named in your documents, you might need to come back sooner. I also know for those of us whose lives are very busy with young kids, 5 years sometimes means 8 or 10 years. So, but 5 years is my recommendation. I'll give you an example. I have a special needs trust. I'm working with a family. They have one that's from 2010 era, perfectly good special needs trust that was set up, but some changes have happened with the way that Social Security is interpreting some of the provisions that were in that trust now, that I had some suggestions for how we could make some changes. And so it's good to, just check back in, because Social Security can start interpreting provisions differently. Excuse me. Even if the law hasn't actually changed as well. So it's a good reminder. Definitely look back and talk to your advisors every 5 to 10 years.
And one more question on that before we move on a special needs trust. Say I moved here from out of state and I had a trust that was set up under the laws of that particular state. Is it important to review your trust in the event that you move to a new state?
It's important to review your overall estate plan with an estate planning attorney in that new state. Whether that special needs trust needs to be, redone or not would be a part of that conversation. The special needs trust provisions are primarily federal law with some overlay of state law. So they wouldn't 100% of the time need to be, redone, especially if they've been funded and they're irrevocable. So that's a different bucket there. But it's part of the law. Definitely meet with an estate planning attorney in the new state. Mm-hmm. So I'll just jump into guardianship. I think it's an area where there's a lot of misunderstanding and a lot of confusion, which leads to frustration and stress. Excuse me. Guardianship is a creature of state law. So the Texas Estates Code governs the law around guardianship in Texas if you're a Texas resident. And it's basically the court supervised procedure where one person is given legal authority to make decisions, financial, medical decisions for a person who has been determined to be incapacitated. So that's both a medical determination and then the legal determination that their incapacity has led them to need to have someone, help protect them by making decisions for them. So, guardianship, when a person turns 18, they are an adult for all legal purposes. They can, consent to their own medical treatment. No one can consent to medical treatment for them. They make their own financial decisions. An 18-year-old has legal capacity as an adult. And so when an individual turns 18, if they are lacking that ability, that's when it comes into play as to whether they might need a guardianship. Now, there's two types of guardianship. There's guardianship of the person, there's guardianship of the estate. There's also partial guardianships of each of these. And there are lots of alternatives to guardianship. So herein lies where it gets kind of confusing, but that's what I'd like to lay out for you. So guardianship of the person is simply a guardianship where someone's appointed to make medical and sort of daily living decisions for a person who's incapacitated. A guardianship of the estate is only needed if someone has financial assets that need to be managed by a guardian. So an individual might not need both. The process is that, a person who's about to turn 18 or who's over the age of 18 will have visited a doctor, and that doctor will provide a certified medical examination that talks about whether that person needs to have a guardianship or, whether they have capacity or not. Then the applicant for guardianship files an application. They have to be represented by an attorney to do that. They submit that physician certified medical examination with their application. The court appoints an attorney ad litem, which is the attorney who represents what they call the proposed ward, so the individual with a disability. And then all the parties need to attend the hearing unless the court is okay with the person with a disability not attending in some cases. And then the elements that have to be proved are one, incapacity. So that's based on the medical examination, and the necessity. If there's not something pushing a need for a guardianship, just someone lacking capacity is not sufficient to have a guardianship granted. And then really importantly,
so Heidi, isn't there something though, like in Texas, and there may be people that are attending that are not from Texas, but in Texas in general, is there some law about the least restrictive, most appropriate for the ward or something along those lines? And what does that even mean? Right.
So we're looking for, and the court is looking for, the least restrictive alternative to guardianship, if there is one, if there is any kind of less restrictive alternative. And this was really put into play with some legislation that went through in 2015, where it became a requirement to consider alternatives to guardianship. Prior to that, it was really easy to just walk into a court and get a guardianship over somebody, and that takes away someone's civil rights, the individual with a disability. And so in some cases that is protective of someone who's vulnerable, and in many cases it really just removed rights of people who deserve to keep their civil rights and just have support in other ways. And so the law, and this is an example of advocates and self-advocates pushing forward legislation that really improved the lives of people with disabilities. So they, one, push for a change in the law under the estates code that you must consider alternatives to guardianship and least restrictive alternatives. And then also that put into place supported decision-making agreements. And I have something on that coming up here, and I'll talk about that in more detail because that's a really important alternative to guardianship. But yes, you have to find those alternatives to guardianships, and they're often available. When they're not, then we go through with our application for guardianship, and then this is the result of it. If it's granted, if the court determines that we've brought enough evidence that shows incapacity, necessity, and no alternatives available, then the applicant is granted letters of guardianship. And those letters of guardianship, they use, to make medical decisions, to make financial decisions, to open up a bank account, whatever it is that they are granted in the order, whatever powers they're given. Those letters of guardianship are what open the door to be able to use those. It is county by county. So if you have a Tarrant County guardianship and then the ward moves to a different county, that has to be transferred likewise to another state and that kind of thing.
Heidi, a lot of people feel, and I know you know this, a lot of people pretty much feel really overwhelmed with this. And I like to share that, first of all, as a parent, you don't have to know what you need. The only thing you need to know is to work with a qualified attorney that does this type of work, because they're going to walk through the doors with you of what those options are, what may be more appropriate than the other. So you don't have to know when you have that initial consultation with somebody what you're doing. You do not have to know that. So I always like to tell people that. But I also want you to talk about, because there's a lot of confusion when it comes to guardianship. A lot of people have kids that are not there yet. They haven't arrived. I mean, quite honestly, have our neurotypical kids arrived at 18? Probably not, right? But a lot of families are hopeful and optimistic. Maybe they have autism, or maybe they're high functioning. Maybe it's ADHD. Maybe they're less mature than what they should be for age 18. Maybe they're 2 to 4 years behind, but we're still hopeful and optimistic. But we've also seen people where they did another, an option. I know you're going to talk about them, like a power of attorney or a healthcare power of attorney. But what they had that individual sign, they did not have the capacity to understand what they were signing, and it didn't hold up. So can you kind of talk about that just for a second? Because I think that there's kind of that line. Just talk to us about that.
Yeah. So what it really comes down to is that it's so person specific, right? It's so situation and person specific. I have people that come in and say, my child's about to turn 18, they have such and such diagnosis, and the school said, go get a guardianship. And so the decision, was sort of made by someone else. And then I say, well, that might not be actually the conclusion that we need to make here. We need to go through a process of deciding whether that's the right choice. And it needs to be the last choice. We need to look at all options, whether there are powers of attorney that are available, supported decision-making agreements. We need to look at all the alternatives first. And if we get to that, and this is kind of why I like for people to understand what the process looks like, because it's not like you just go file a piece of paper with the court. I mean, there's a process and there's an evidentiary hearing, and it's based on real evidence of whether this person needs a guardianship for their protection and for their safety. If they don't need one, let's avoid it. I mean, that's I would like to avoid it whenever that's possible. And so if someone, and to your point, most of my clients who have typically developing 18-year-olds would probably like to get guardianship of their 18-year-olds if it was available, right? I mean, all of our kiddos who are 18, sometimes people will have me do a little kind of mini estate plan for their 18-year-olds who are going off to college, where we just do powers of attorney and a few of those kinds of documents. And I do an adulting 101 with them a little bit, where I say, so you're 18, you are criminally and civilly responsible for your actions. You are responsible for your debt. You're responsible. I go through kind of a little adulting 101. I think it's a little bit surprising sometimes to them because they still maybe live under their parents' roof and they're about to go to college, right? So that's a big transition. But to your point, we're all still really immature at 18. And so determining that someone's civil rights need to be removed to protect them at that age requires really, really walking through what's really necessary for this person. And for some people, their disability is such that protection would be a benefit to them. And for some people.
So some of these rights that you're talking about is the right to marry, the right to drive, the right to vote. Those are some of those that are taken away in a full guardianship. And you had mentioned partial guardianship. Are you able to restore some of those rights, or have some of those rights, retain, I guess is the right word, some of those rights in a partial guardianship?
Mm-hmm, absolutely. So there can be a partial guardianship that may be only for making medical decisions, and you retain all of those other rights. And then sometimes there's full guardianship that removes all of those civil rights. And so a good detailed conversation about that needs to happen. And so if someone just says, oh, yes, you need guardianship in a real blanket sort of way, I just say, please question that, and please talk to somebody who knows the convoluted details of getting to, the conclusion about what type of and if a guardianship is necessary.
You talked about the medical document, the evidence that needs to be signed off on a physician, and that is a medical doctor. That is a doctor. It's not a nurse practitioner. It's has to be a medical doctor. We've seen in the last year, more in the last year than we've ever seen, where we're seeing more and more doctors refusing to sign off on these. Is that something that you've seen? I don't know if they went to a CE class and they told them to tread lightly on that, or I don't know, but we've actually been seeing that happen. And what happens when you have a child that clearly, maybe that there's not an answer that's clearly, but, clearly they don't have the capacity to understand what they're signing on a power of attorney or a healthcare power of attorney. But then their primary care physician that they've had for years and years and years doesn't sign off on that. What do you do in that example? And you talked about a guardian ad litem and some other things. What happens?
So a person having legal capacity to sign a power of attorney is, there's a certain capacity necessary for that. Just because you lack that level of capacity doesn't necessarily mean you lack capacity and need a guardianship. And in that gray area, and I'm not a neurologist, but that gray area, is hopefully an alternative to guardianship. Maybe some supports and services are needed for that person who doesn't have the legal capacity to sign a contract like a power of attorney is, but they just need some supports and services or a supported decision-making agreement in that space. As far as doctors not wanting to sign medical examinations, I haven't actually had that locally here in Tarrant County area or Dallas. And if that were the case, I would just say, what kind of doctor was that? Was it the primary care doctor that didn't understand the capacity question? is there, typically with our kids who have intellectual disabilities, there's a neurologist or there's a disability specific, geneticist or some doctor who understands the condition and maybe could speak better to the capacity, or maybe the doctor is right. I don't know if it's just a liability risk aversion or if it's a in-between diagnosis kind of issue. But that would either be needing to just see a different doctor, talk to a lawyer about, what that means and where we're falling there within the medical, legal, ethical context. It's complicated, or it can be complicated in that space.
I know there's a such thing as contested guardianship, and we always know that anytime the word contested, you want to avoid that because it gets expensive. But in the example, because I imagine that there are some people here that are divorced in divorce situations and shared custody and other things like that, and one person thinks that there's a guardianship needed and the other person is adamantly against that. Can you talk to us about what happens in situations like that? Because understanding that the doctor signs off, there's a guardian ad litem. So if we have, if there happens to be a situation like that where someone is against it, how does that work? Do they just not apply, or how do we get that moving?
So in that kind of a context, if there's a contest, the court ultimately has to make a best interest determination for the individual with a disability. So they're one, making the incapacity determination. Are we hitting that? Do we have enough evidence of incapacity? No alternatives, all that. And then who's appropriate to serve? So if you've got two people that are their ex-spouses battling over, one of them probably has care and control of the person, the individual with the disability, and the other probably doesn't. So that would kind of stack something in favor of the person who has control of that person's support and daily schedule. But they're just going to weigh the evidence on what the best interest is of the individual with a disability. If there's a parent who absolutely opposes the guardianship existing, not just wanting to serve as the guardian, then the only duty that the applicant has is to provide notice to that person of the guardianship proceeding. And then if they want to contest it and say there's these reasons why they don't need a guardianship, the court would put all of that together to see whether there's clear and convincing evidence. That's the burden of proof necessary for guardianship. So if there's not enough evidence, the applicant's putting up this evidence, and then this contestant is saying, no, that's not the case. This person actually can do all of these things with support, then the guardianship might not be granted. So it's going to be a weighing of evidence.
I love that you put on this slide, I love that you've got kind of the approximate cost, because I think when people are planning, they've got to plan financially. This is not a DIY project. When you're going down this highway, clearly people are aware that they can download a power of attorney and a health power of attorney on the internet. But a guardianship that's not the direction that goes. And so people being able to plan financially for this, I think is really, really important. So that inquiring minds want to know, they always want to know kind of the range of what that looks like. So thank you for sharing that.
And that's fair. And this is about, the reason I like to do these webinars is just to try to help people be good consumers of legal services, which is not something that we're all experienced in. And an attorney should always give you good estimates. It should not be a mystery in these kinds of situations. In litigation, big litigation matters, of course, that can be a little bit mysterious, but in these cases, it really shouldn't be, not in your planning, not in guardianship. And so I think it's good to know up front. And even to the extent that a family might delay getting a guardianship, again, we just want it to be the last and best option. If it is the best option, let's just make sure we've looked through everything else, because there is cost and inconvenience and other things involved with getting a guardianship. And so we just want to make sure we're looking at all the pieces of it, the good, the bad, and the ugly, because if they're all there. So there's, I've got a list of a few cons, right? Losing some rights, there's court supervision, there's cost. It's a restrictive action to protect a vulnerable person. And so there's just some moral and ethical issues there as well, right? I wish there was a better system, but this is the system that's in place. So again, it should be the last and best available choice for somebody.
One thing I wanted to ask about the process of, there's a process of somebody being served. People talk about this process being a pretty emotional process. It's not just it's pretty emotional. And there is a process of the family members being served in this example. So the question that has come up in the past that I want to bring up is like, what if there's an absent parent? We don't know where the parent is. What if that parent is out of the country? Does that make it impossible for them to get to get guardianship if that person is unable to be served or located?
Yeah, there's a legal process in place that's outlined in the Civil Practice and Remedies Codes for dealing with parties that are necessary, we aren't able to reach them. And so, you can ideally the other parent who doesn't want to be the guardian will usually sign a waiver and say, yes, I recognize my child needs to be under guardianship, and I waive my right to serve as that guardian. That's the typical scenario for a lot of cases. And then in others, they say, well, I don't care, but I just don't want to have anything to do with it. And so then we just send them certified mail, return receipt requested notice of it. If we can't find them at all, then we might have to do some sort of, notice by publication, something like that. Just we have to show the court that we have, done everything we can to notify all the people that the code requires. And it requires, adult siblings of the proposed ward, other parents, if they're living in a supported living situation, that those, there's several people that have to be notified. So we have to just follow the code as far as notice to people. But also, like you're saying, there does have to be notice by a constable served to the proposed ward, and that's uncomfortable. And so I always try to help clients navigate that and just let them know when that's going to happen and what that's going to look like. And I've had my most recent one, the client mother of her son who is going to be under guardianship. The constable handed him the notice, and he just looked at it and wadded it up and tossed it away. So, that was his interest in it. So, yeah, that part is, that's another hard part about the guardianship process, and why I would tell people to avoid it unless it is the last and the best alternative. So, alternatives to guardianship. Guardianship of the estate is only needed if the individual with a disability has assets in their control. And if they've received an inheritance or a personal injury settlement or child support, they're over 18, it then becomes their asset, which is a change from before they're 18. It's their custodial parent's asset. When they turn 18, it becomes the adult child's asset for purposes of Social Security Administration. And so the alternatives to dealing with that, and instead of getting a guardianship of the estate, would be setting up a special needs trust. In that particular scenario, a child support special needs trust that would be ordered by the family court. Often we do those through a modification if they haven't been done in the original suit affecting the parent-child relationship. Establishing a joint bank account in some scenarios can avoid guardianship of the estate. Designating a rep payee for SSI, that's pretty typical for a parent of an adult child who's receiving SSI. And so receiving SSI isn't a reason to need a guardianship. And then if the person has capacity to execute legal documents, then a durable financial power of attorney.
One thing I want to mention is that the Social Security Administration does not recognize a power of attorney. You can still fill out the form and be the representative payee for your loved one without a guardianship. But it is really important to know that the Social Security Administration absolutely does not accept a power of attorney. It doesn't matter what legal document it is; they don't accept that. But they do accept that power of attorney. But you said something, and I want to make a point of this. We have entire webinars on this. But a lot of times in the state of Texas, and again, we may have other people that are from out of state, but in the state of Texas, it's not a slam dunk, but a lot of times child support continues post age 18 for the disabled in often cases. And that child support, if it is not redirected to a first party special needs trust, it is going to be counted against your loved one for the asset calculation and income calculation for qualifying for SSI. So if that's you and you're getting child support and that child support is going to continue post age 18, it doesn't matter that it's coming to you. It is going to be considered the kid's income post age 18. So I'm glad you mentioned that. A lot of people don't know it. They find out once they get this big long letter from the Social Security Administration of, oh, by the way, you owe us this much money. And so just know that going in, that if you're going to continue to get that child support, it does need to be redirected. So it's really important.
Yeah, and I work hand in hand with several family law attorneys who They will prepare the modification to, petition and all of that. And then I provide the Child Support Special Needs Trust and the language that needs to be in the order that specifically uses the Social Security Administration's language to direct child support to go to the custodial parent as the trustee of this particular special needs trust. And like you said, this could be a whole webinar on its own, so I'll cut myself off here in a second, but that special needs trust is different from an estate planning third-party special needs trust that we'll talk about in a minute when we get to talk about wills and trusts. So this is a special, unusual creature of the Child Support Special Needs Trust, but really important if you're in that scenario. That modification not only would need to direct the funds to the Special Needs Trust, but also, as Allison was saying, indicate that individual with a disability, the disability existed prior to age 18, and that ongoing child support for that person's life is ordered by the court. And so that's a new order that's needed if you had an old divorce decree that didn't include that language. All right, so guardianship of the person alternatives. So we talked a little bit about supported decision-making agreements. This is really an exciting part of Texas law that this was added to the Texas States Code in 2015. So I mentioned that there had been the changes that required us to look to alternatives to guardianship in 2015. And the supported decision-making agreement was added to the Estates Code as one of those options. And it really is a good one. It is where an individual with a disability has the ability to name a supporter. And that supporter can help them in making decisions. So that supporter is not making decisions for them. So this would be a person with a disability who typically, if they come into my office and I talk to them about this document, and if they can indicate to me that they understand what I'm saying, that they would want their mom or dad or sibling, adult sibling, to be in the doctor's office with them and help them understand choices that the doctor is giving them, and if they would like this person to support them in making decisions, if they can understand that, then I think this is a great option to use in lieu of guardianship of the person. And so that can provide the supporter who normally wouldn't have that authority to even be in there in the doctor's office or to be involved in that decision-making process at all for this adult person. And so it really is great. Came along in 2015. I felt like at that time we were really having to explain this to medical professionals. We still do a little bit, but at least we're not having to combat them feeling like we've just made this up, because it's been around for a little bit longer, so they are a little bit more familiar with it. You do not need an attorney to get a supported decision-making agreement. You can go onto the Disability Rights Texas website. I think the ARC of Texas also has a toolkit for these that are fantastic. They explain them. They explain how to use them. There's even a self-advocate. I think there's a video on one of those websites that's fantastic about how you use this. Now, I do prepare these for clients, and I do think there's some value in having an attorney to support the use of them at times. I've been in scenarios where we have, let's say an adult who has a supported decision-making agreement and is currently being treated for something. In a scenario I had recently, it was an adult with Down syndrome who had leukemia, and he's an adult, he's 18, and he has a supported decision-making agreement. And the fact is that not under a guardianship, he does have the right to walk out of the hospital and refuse treatment. That supported decision-making agreement is still valid so that his parents or his supporters could help him making those good decisions, but he still retains his rights to make those final decisions. Hopefully he's listening to those supporters. If he wasn't, and he started to make some choices that were not safe for him, then that would put him in a different scenario that maybe a guardianship was necessary to protect him. But that gets into a legal, ethical, medical scenario it's tricky and difficult. But the supported decision-making agreement covers a lot of space that can avoid guardianship, which is great.
I just wanted to mention, and I know you already did, but this is a Texas thing. There are other states that have supported decision-making agreements, but not all states have them. So if you are attending from out of state, you'll have to check with your own state to see if they actually even have a supported decision-making agreement. Let's see. I think we have a question. If an adolescent child who doesn't have intellectual disability but has high-functioning autism with diagnosed mental and behavioral comorbidities accompanied with a long history of chronic violence and aggressive behavior, history of residential treatment center placement and psychiatric hospitalization, is guardianship a necessary route to seek?
So it just depends on probably more facts than that. So there's a diagnosis, there's some mental health, and there's some behavioral concerns there. But you said, but does not have intellectual disability. Probably, and again, with this very limited information, what I would take from it is it may not be a guardianship that would be granted, maybe because the person doesn't lack capacity. The person has capacity. They're just suffering from some other things that are making the decision-making process difficult, maybe behaviorally or based on some other mental health issues that are going on. And so just from that briefly, it sounds like it's a situation that guardianship would not be the route to take, but I don't know that for sure. It sounds like there's.
And I just want to ask, because we've seen a lot of mental health, we've seen a lot of what this person just posted over the last couple of years since COVID. But when you take maybe what was just said and you add that they are a threat to themselves or others, does that change? Does that reshape that conversation? Does that change things?
Not necessarily, because the mental health component doesn't necessarily always fall within the incapacity determination. And so sometimes it's a mental health commitment and not a guardianship situation. And unfortunately, mental health is not dealt with in a really, really productive way here in, I don't know what region to say, United States. But anyway, mental health is such a difficult issue. And so, usually the entry points for a mental health, either, commitment is criminal or hospital. They're not, there's not a lot of access points to for support, legal support within the system, so to speak, other than that mental health commitment. And that doesn't really solve a lot of these problems, other than if somebody is a danger to themselves or others, it might, for the immediate situation, resolve that. But guardianship, on the other hand, is not usually the solution. But I get that a lot. I get a lot of calls of people who have a mental health concern seeking guardianship, and usually that's the explanation I'm having to give them, is that this is not really a scenario that's appropriate for guardianship. It really is mental health commitment or some other type of support, at least here in Tarrant County. And I know not everybody's here in Tarrant County, but maybe there's an analogous agency in your area. But here it's MHMR. The acronym's changed a couple of times, but that's My Health, My Resources. That's our entry point to mental health services. So you have to find one of those agencies and try to ask about what's available for those kind of situations.
Guys, those are countywide all across the state. Everybody has their own local intellectual disability authority, is what she is referring to. For years, they were called MHMR. Some of them are still called MHMR, but they're your every local authority has a crisis line for the mental health. And so, I think it is a slippery slope, especially if we have a loved one that is chronically in psychosis. But one question that I wanted to ask as it relates to that, a lesser restrictive option, a power of attorney and a healthcare power of attorney in that example. But when we have an individual or a loved one who is adversarial, combative, argumentative, aggressive, those types of things, isn't it true that if you have a power of attorney and a healthcare power of attorney, that individual can revoke that at any time? So as soon as they get angry at you, if they're angry at you, they could basically revoke that and you don't have a leg to stand on. Is that true?
It's true. Yeah, if they have the capacity to enter into it, so long as they continue to have the capacity to execute legal documents, they can also revoke it. Mm-hmm.
Okay, so I think we talked about the supported decision making. So let's talk about the advocacy initiatives.
Mm-hmm. So just kind of, reiterating that the Supported Decision Making Agreement Act was really put into place and advocated for by self-advocates and just advocates around our state and here in Texas, and how powerful that is to have made a real change in guardianship laws and affecting people who would have been in guardianship that don't have to be now. There's been a lot of restoration since then, because there were lots of people under guardianship and then a lot of adults under guardianship that didn't need to be under guardianship anymore, especially with these less restrictive alternatives. And so they've been restored. They've had their rights restored through a restoration process, which is great too. The Ward's Bill of Rights that lists all of the rights that people under guardianship have, and having that be presented to people who are under guardianship was also another initiative that's in place. This slide, actually, I should have updated a little bit, but I'm on the Real Estate Probate Trust legislation guardianship committee, and for the 2023 legislative session, we're seeking input on some amendments to the guardianship law that's actually already underway, but just each odd year, at least here in Texas, that's when we have legislative changes that can go into place. And so I just encourage people to stay up on what the laws are, watch how they change, see how your organizations like the ARC of Texas are making changes and proposing changes and keeping up with those, and contacting your Congress people to try to get those pushed forward. It's important.
So I just want to I want to talk about the power of attorney and the healthcare power of attorney just for a second, because I think it's important. We're talking about our kids with disabilities, but we may have other kids. And I think the power of attorney and the healthcare power of attorney are an important documents that are often overlooked as husband and wife, as you're thinking about your aging parents and as you're thinking about your neurotypical kids that you are sending off to college. One could argue they're a believer or non-believer of that or whatever, but we've seen some people that sent their kids off to college that had mental health crises, and they were moved to a facility, and they wouldn't even tell them where they were, right? They wouldn't even tell them where they were. So like in the example of Dallas, it's a needle in the haystack. San Antonio, Houston, you're wondering where your kid is. So that's what can happen when you don't have those documents in place. So I think it's important. And then I think of another family that we serve that their kid was in the apartment fire at Texas State, right? So these are other examples. Accidents happen, things happen. So your kids that are going off to college, this is a good document to have. It's a good conversation to have with your aging parents or other aging people in your life. But just looking around and making sure that you have these documents in place, so that way the crisis doesn't happen and you realize, man, we should have done that. I just don't mark that down. If you're taking notes, make a note to check on those things for your own family.
Yeah, and when I jump over and just one more slide over to talking about estate planning a little bit more, I'll touch on that again, and I agree with what you just said about it. Let me just wrap up this guardianship talk, and it kind of goes back to our very first intro here when Allison was talking about your different advisors and who can advise you in different areas. For me personally, the person-centered planning has been really important for really understanding my daughter with a disability and understanding, learning as a person who doesn't currently have a disability. And so I need to learn about and educate myself about how that must feel to her to have other people supporting her and to guide her and not control everything for her. But the person-centered planning, if you can find a person who does this and you can learn about what is important to your individual with a disability versus what is important for them, and working so that they're both safe and protected, but also have dignity of risk and self-determination, that they get to live their own life. They get to make mistakes, just like I've made so many in my life, and I've learned the most from making those mistakes. So I don't want to keep my daughter from making mistakes. I just want to keep her safe. So these are all, items that you can work with various advisors. There's a lot of good resources out there. If you're in this local area of Dallas-Fort Worth area, the ARC has the A Look Ahead series, and there's one this Saturday, but they often have someone talking about person-centered planning. And I just find it so helpful to me to make that shift from fixing to supporting my loved one with a disability. So I highly recommend just putting together all your people who can advise on each of these topics to help put a plan in place that is really supportive.
We have a letter of intent topic that lives on our YouTube channel, and we have a letter of intent template that we share with our families. But that is an important document as well. And I always say that as a caregiver or as a parent, we have forgot more than anybody will ever know, and sometimes even more than the other spouse, right? So having that letter of intent and really knowing all the ins and outs of your loved one and what makes things go smoothly, what makes things fall apart, where the doctors are, what the meds are, what the diagnosis, all that stuff lives in that letter of intent. And it's a document that somebody else can really pick up And, they're never going to be able to fill your shoes, but not having to dig through file cabinets or floorboards of car or under the bed or the box or whatever, and to have that information in their hand is really helpful to have that. I am a firm believer of the letter of intent.
Yeah, and especially the nuances that some of our loved ones with disabilities will have that could be so helpful. It's like you're providing this roadmap of support for them. I mean, my daughter has depth perception issues sometimes, and so someone might not understand why she doesn't want to get up on the chair or the stage or whatever, but if they understand that, they can support her better. Or that visual aids help her, visual schedule helps her. All of those things can be extremely important for someone else to help step in our shoes or support them when we're not there. So.
We have one last question on the guardianship before we switch over to the wills and trusts. And they basically said they moved here from California. They've got guardianship of their granddaughter, and what really needs to happen to get that guardianship moved to Texas? What is the process for that?
So in Texas, what we think of as guardianship for a minor is actually called custodianship. And so custodianship of a minor is something that happens in the family law courts. So whichever county you're in, you just need to find a family law attorney that can petition the court to transfer your custodianship over that minor child. Guardianship in Texas is guardianship of a person over the age of 18, so an adult who's under a guardianship. So you're talking about, and that guardianship is filed in the probate courts, in our county probate courts. So what you're talking about is a family law issue, and so find a family law attorney in your local area that can help you with that custodianship. All right, so we're switching over here, and I know these, like we said in the beginning, these are a lot of different topics, but again, I'm just trying to give some legal structure and a legal framework just to help you, if you're reaching out to an attorney, to not feel like you're starting from scratch, to feel like you have some overview of some legal structure. So we went through guardianship. I know it's really a high level overview and doesn't answer all of your questions. I absolutely get that. But at least hopefully it gives you a little bit of structure about the application, about the importance of alternatives to guardianship, and about supported decision-making agreements. So now we're going to switch over to estate planning. Estate planning, wills, trusts, identifying, what tools you might need in order to handle your estate. And your estate planning encompasses, laying out, instructions about what should happen to your assets at your death, but also upon incapacity during your life. If you were to lose capacity yourself, you would want to have those documents in place, like the powers of attorney that we were talking about, so that someone else can make medical and financial decisions for you without having to get a guardianship over you. So this is, shifting over to the other side where you're talking about your own estate planning. While you have capacity, you definitely need to execute these documents so that you wouldn't have to be under guardianship in the event that you lost capacity, that you have named an agent to speak for you and make decisions for you. So a guardianship is not needed where there's a power of attorney in place that's effectively executed by a person with legal capacity to execute it. All right, so, and then as a part of this, we'll go into some special needs planning as well. Just really briefly, there's, just so you're thinking about your own assets when you're talking to an estate planning attorney, you have some probate property and you have some non-probate property. When I talk about non-probate property, it's just assets that you have that have a beneficiary designation. So maybe your retirement accounts, maybe a life insurance policy, anything, in a trust. So these are all items that already have a beneficiary designated. So when you pass away, they pass by a contract or by, a trust instrument or by a policy, life insurance policy. Those are all set. And then your probate assets might be your house, might be your cash in a bank, things that would go by your will. So it's just nice to look at your assets and think about what you have and how it would be transferred, either by beneficiary designation or by your will. The probate process in Texas is actually fairly simple in comparison to some states. So in California, for example, it's a really difficult probate process, both cost-wise and timeline. It's so most people have all their assets in trust because they want to avoid probate at all costs. Here in Texas, probate is a fairly streamlined process. So I always tell clients, I want to keep your planning as simple as possible unless you give me a reason to make it more complicated. So for most people, it's just a will. Maybe if they have minor children, there's trusts in place for those minor children until they reach a certain age. With a higher level of assets and resources, you might need some trust that handle some tax planning or some lifetime trusts for children. And then if you have a child with special needs, you definitely need the special needs trust as part of the estate plan. And let's see, we'll skip forward a few slides there, Allison, and I'll just go straight to sort of to the special needs planning. And so if you have young kids, you know that everyone, puts their kids on the lists, and the lists are all of the public benefits that are available. And this is specific to Texas, although probably most states have these lists. And these are the benefits that would be available to individuals with disabilities. And the list can be very long. But the whole purpose of special needs planning is that, when somebody inherits property, if they are currently eligible for public benefits and then they inherit property, they would all of a sudden become ineligible for those benefits. They'd have to spend down that inheritance before they could be eligible again. And so the special needs planning is, anything that goes to this individual goes to the special needs trust, and that special needs trust is considered exempt for the purposes of Social Security eligibility. And so when you put that planning into place, then the individual with a disability can benefit from public benefits, but have their life supplemented over time by the assets that are in the special needs trust. And then the other benefit of it, if doing the advanced planning so that you have this third-party special needs trust, is that any assets that remain in the special needs trust at the death of that beneficiary can go to your other family members, to the person's siblings, or whomever you want to name as their remainder beneficiaries of that trust. Without doing trust planning, then you'd end up with a self-settled trust, possibly. So if someone doesn't do the planning and they come to me and say they've inherited these assets, but they're on benefits, what can we do? So sometimes we'll say, well, we can set up a self-settled special needs trust, but because they already inherited the assets, you don't get to pick the remainder beneficiary. It has to go back to pay Medicaid back for any services they've received over the course of their life. And then if there's anything remaining, it can go to the beneficiary's name. So there's a real benefit to doing the advanced planning with the special needs trust to get that third party special needs trust benefit.
Heidi, you've said a lot, so I want to back up just a second. When we are, I think there was let me go back a slide or two, the list, the interest list. So I just wanted to on the interest list, she's talking about waivers, and these are Medicaid waivers so most states have them. They're Medicaid waivers. They could have a few. They might have up to 10 different waivers in the state for different particular disabilities. Every state is a little bit different. In Texas, we call it the interest list, the waiting list, et cetera. But the point of these waivers is designed to waive off some of the cost of caring for an individual with a disability. It is now the belief that individuals are better in home and community-based services. So it pays for things like attendance services, respite services, the various therapies and things like that. So that's the point of those waivers. And in order to qualify, Texas has a long waiting list, about 17 years, but you have to maintain your Medicaid eligibility for these waivers. So that's what she was talking about. And so there's basically, when we start moving into special needs trust, because this is where everybody's eyes start crossing, and it's like, oh my gosh, wait, what did she just say? A special needs trust is a bucket that you can have money that is not counted against that means-based test for SSI and Medicaid purposes. And that's what she's saying. So basically, in summary of what you said, there's basically two types of special needs trust. There's a first party, which is a self-settled, and that has a required Medicaid payback. Child support would have to go to a first party special needs trust. If your child inherits money, right? If they inherit money accidentally to their name themselves, not to the trust, that could be moved over to a first party special needs trust, which would have a Medicaid payback. But when we're planning ahead, like all of you guys are here learning about all of this, the idea is, right, that we want a third party special needs trust that we can leave assets to our loved one, like for instance, to the third party special needs trust of little Johnny, instead of naming little Johnny outright. And there is no Medicaid payback on that. Did I summarize what you said? Are you in agreement with that?
Yes, absolutely. And I'll say, as far as I think timeline is kind of important, and you can tell me, what your advice is, but sometimes people will come into me and probably to you and say, I'm really here to set up the special needs trust account. How do I set up the special needs trust account? And then what I'll kind of explain is that typically that special needs trust is funded upon the parent's death or the second parent's death if the parents are married. And so it's not necessarily something that you set up during your lifetime, because during your life, you're supplementing, their needs. But at your death, that's when you want that special needs trust to then be funded, and you've named a trustee, and that trustee would work with an attorney like me or a financial planner like Allison, or some advisors that would help them understand how to use it, and that they would be transferring assets into the trust as trustee, and then they would be utilizing the trust for the benefit of the individual. But it's not something that you necessarily are going to set up during your life and use as an investment or anything like that. Is that kind of the timeline that you also give people, Allison?
Yeah, I mean, I agree with that 1,000%. And the reason why is as a person, we could spend 25 to 35 years in retirement. If you're married, your spouse, you could spend 25 to 35 years in retirement. So tying your assets up in an irrevocable vehicle might not be wise, right? So we do like the idea of funding that special needs trust upon death. Sometimes it is funded with your existing assets that are left over. Many times, many people fund their special needs trust with life insurance proceeds. So upon your death, the life insurance proceeds fund the trust. And we think that that's the wisest, unless you're a gazillionaire and you have plenty of money. You're never going to run out of money in retirement, and you have plenty of money to fund the trust. We do have people that fit into that category. I mean, there's no question. But other than that, we're usually fans of not funding the trust, right away.
And what that really looks
I know
like, and I know we're almost done. I'll just add one piece that, typically that is either a will, or if you're someone who has a revocable living trust or trust, and whatever the gift is at your death to the disabled child would go to this special needs trust. It's freestanding trust that we prepare. You don't have to open up a bank account for it, as far as like right when you're doing your estate planning. It's just really a document. It exists, funded with $10, kind of hypothetically, just so that it exists and it's ready when needed. Now, it's irrevocable, but if you're not funding it, then all we have to do is tear it up. If that one doesn't, and then we do another one. So that's the way it becomes sort of amendable over time. We can't actually amend this document, but we've never funded it, so it's gone, and now we've created a new one over time with the newer provisions and that sort of thing. And then the only other thing that I'm not having a ton of time to talk about, and that's okay because I put quite a bit of information in the slides, is an ABLE account. And I would direct people to go to the ABLE National Resource Center, which has a lot of really great information about ABLE accounts on them. This, again, is a great example of self-advocates and disability advocates pushing for something. I was involved with the National Down Syndrome Society when this was pushed through in 2014, and it's an amendment to 529. So if you have a 529 account, it's a 529A, but it's specifically for a person with a disability whose disability started prior to age 26. The most important thing to me is adults with a disability that can have an ABLE account can contribute compensation of about $1,000 a month into this, and that income will not be considered income for Social Security purposes. So if you have an adult family member with a disability who's wanting to work, this really enables them to be able to do this without being dinged on their SSI. So,
Heidi, we have an entire webinar on ABLE accounts. We can help people open ABLE accounts and provide more information. It's subject to the gift tax, which for 2022 is $16,000 a year, an additional $12,880 if they're working. It's $17,000 for 2023. But again, this is a place that you can have money above the $2,000 that will not disqualify them for SSI and Medicaid, so it's important. But some people ask, why should I have an ABLE account in a special needs trust? And the reason why is an ABLE account can pay for food and shelter without a 1/3 reduction to SSI. And while a special needs trust can pay for food and shelter, there is a 1/3 reduction to SSI. So that is one reason. And another thing that you have to know is you cannot leave an ABLE account as a beneficiary for an inheritance. That's going to have to be a special needs trust. So those are two questions that come up all the time because people are confused on why they might need both. And the last thing important.
Let me just add one piece to that is that you also can't have a child support go to an ABLE account. People ask that as well.
And one other thing too is on the 529A ABLE accounts, you can't have more than $100,000 in there before you disqualify for SSI and Medicaid. So if you look at the code, you could have up to $500,000 in there, but $100,000 is the bottom line. If you have more than $100,000 in there, you cannot. You will disqualify. So somebody says, I was advised to roll over a 529 funds to an ABLE account. What's your take on that? And do you need an ABLE and a 529? One of them is also tied up in a special needs trust. So my take on that is when we have a kid with a disability and somebody advised to roll a 529C to a 529A, I am a fan of that. Some of our kids will not go to college. And if you take the money out of the 529C for not higher education, basically, you're going to be taxed and penalized. What you can pay for out of an ABLE account is, if it can be construed as achieving a better life for an individual, you can pay for it out of an ABLE account. So what that means is, yes, you could pay for college out of an ABLE account, but you could pay for any number of things. You could pay for a car. It could be adaptive equipment. It could be actually a vacation for your loved one with a disability, any healthcare expenses. The list goes on and on. There's a long list of what could be construed as achieving a better life for an individual. So I personally don't think that was a bad idea. And that gives you more flexibility to take distributions from the 529A without being taxed and penalized. And everybody's situation is a little bit different. Some of your kids may, for sure be, going to college and some not, but I think it is going to give you greater flexibility. Do you agree with that, Heidi?
I agree. And just piggybacking on what you said, it's really not a place to accumulate wealth, right? It's got these limits. But it is really, in my special needs trust, the trustee has the discretion to make distributions to an ABLE account for the beneficiary. And I think it's a great way to work, just like Allison was saying. So you have all of the assets in the special needs trust, and the trustee can throw things into the ABLE account that the beneficiary can then often use on their own. If they have some support in doing so, they can use a debit card. The ABLE account is much easier to use, but it's not necessarily something that you might need to set up as part of your estate planning now. I opened up one for my daughter only because I was really excited that the legislation passed. I found one in a state where there wasn't a fee to open it, and I could keep a very small amount in it, and I just have it there, and it's just available someday if it's needed, when it's needed. And so, but it's not a place to really accumulate investments, as Allison was explaining.
For sure. Guys, I know that we're out of time for today. You guys are going to get a copy of today's slides, and this link will have any upcoming webinars. We have our YouTube channel in the chat box, and it'll also be in these slides. We have topics on our YouTube channel, all of these things. And again, every single one of them has an entire webinar, so if you need more information on SSI and Medicaid or ABLE accounts or any of the things that we've been talking about, we do have those webinars on our YouTube channel and other ones that will be coming up. And you can certainly subscribe to the YouTube channel for free. We always like to take a moment to just say, meet our team. A lot of times I'm out here on the face of Consolidated Planning Group and doing these webinars, but we work on a collaborative, awesome team, nationally certified as Social Security advisors, and members of the Special Needs Planning Academy. We offer free consultations, and we know that when we have people out here, they have personal situations that maybe they don't want to talk about in the chat box. I invite you to reach out to Heidi, invite you to reach out to us, schedule a consultation so we can talk to you further about your unique situation. You guys can like and follow our Facebook page. They'll have upcoming events out there, other things that are just things that we know about in the community, other webinars that we might be having. And Heidi, you had your contact information in the beginning of the slide. So for people that might be interested in having deeper conversations regarding special needs trust, wills, power of attorney, healthcare power of attorney, guardianship, all of these things, they can reach out to you and schedule a consultation with you as well. Is that correct?
That's true, yes.
All right. Thanks, everyone, for being here today. Thanks for allowing us the time to talk about these things. What I would like to say is I just want to encourage and empower each one of you to take the next step to do what you need to do these things, I always say, don't wait for the crisis. Don't wait for the crisis to happen. Kind of having a plan and working your plan. Do you know, and then when we sit down with people, I would say it's probably, this is probably being kind, I would say 95% of the people that we initially sit down with either do not have a will, or they have one that is really, really outdated. They don't have any of these other articles, the HIPAA release, the power of attorney, and things like that. These are really, really important documents. Whether or not you need a trust, an attorney is going to work with you on those items, kind of to discuss, what you might need. But take that step, because what happens is our lives are busy and our lives are complicated, and we put it on the shelf and then we're going to get to it, but we don't get to it. And then something happens to somebody else and we're reminded of why we need to do that again. So just, I would say, put that on your to-do list. We're kind of coming to the end of 2022. And so making that plan to get that in place for next year, I think it's an important step. So thanks, everyone. It's certainly been a pleasure. And we look forward to partnering with you again, Heidi. Thank you.
Thank you, Allison. I always enjoy it. Take care.
All right. Bye now.